morning.
Good morning. May it please the court. My name is Brad Benyon. I represent Mr. Fico. What I'll do first is give you what I think is my main point, and then I'll talk about the issue of mootness, and then move on to what does it mean to be in substantially the same position as a spouse. So the difficulty that my client had at this hearing was that the court found that his girlfriend or his mother, because of their income, that could be income associated with him with respect to being found indigent or not.
Didn't the judge also find the girlfriend's mother would factor into this because he was living with her, or not? He
was living with her, yeah. That I think contributed more to his living expenses, though. I don't think
it wasn't that she, the judge, wasn't expecting the mother of the girlfriend to be responsible for his counsel fees?
That's correct. That's the way I read it. It's the reason the court goes into the fact that they lived with his girlfriend's mother is, as I said, based on living costs, which is one of the factors to be.
But if that's the case, the income doesn't add up to very much, because, I mean, she was working at Nordstrom's.
Yes, she was making shoes. She was making about, I think it's $18,000 a year.
So how would the judge get to a finding that she was not indigent, or that he was not indigent, based on her income, based on the girlfriend's income, as opposed to the girlfriend's mother's income?
Well, I think that's a great question, and that's one of the reasons why I'm here. We don't think that it does.
But you're sure that she, Judge Fahey, wasn't adding the girlfriend's mother into this?
You know, as I read and I reread the instruction, no, I don't think that what the court was saying in its opinion was that the girlfriend's mother was required to give income.
Well,
give.
I'm sorry, please finish your sentence.
I don't think that the girlfriend's mother was thought of as requiring to, or her income was used to determine whether he was indigent or not. It was merely the fact that, as a couple, they were living in her mother's home.
Well, if we look at Rule 310,
yes,
that tells us that the court is to consider a party's available funds.
Yes.
And so the judge here, and Rule 310 says, a party's available funds shall include the liquid assets and disposable net monthly income of the party's spouse or person in substantially the same relationship. So the judge could reasonably consider the girlfriend's circumstances.
Yes.
You'd agree with that?
Yeah.
Or the mother's circumstances when he was living with the mother.
Yes, you can factor those in. And this brings me to my point. In Section 5 of the rule, it gives a definition of the interests of justice, which I think apply to the whole rule, and they must. And I want to read this to you. It says, the interests of justice may require such appointment if, for example, a party is incompetent to obtain counsel, incapable of obtaining access to funds, or incapable of locating or contracting with a lawyer. It's that incapable of obtaining access to the funds, which I think is so important to this case, because if you're a parent, if your parents have assets and you don't, you're a 20-year-old and you commit a crime, the rule says that you can use the parents' income in determining whether the defendant is indigent. But the main and most critical factor is whether the defendant has access to those funds.
So in other words, if the parents came in and said, sorry, he's 20, whatever, 8, 5, maybe living with us, but we are not going to provide any funds for his defense. That ends it.
That's exactly right.
Then he's got no income, so he gets appointed counsel, would you say?
Yes.
Because he has
no access to those funds.
And no
even
legal
though they're
obligation.
Bill Gates, it doesn't matter. Bill Gates and his wife, Melinda Gates, their child, doesn't matter.
It wouldn't matter, because as a parent, you still have the ability to make those decisions with respect to your income of how you are going to allow your child to proceed as an adult. I'm not talking about whether they're a minor, but as an adult, one of your ability as a parent is still to determine whether you're going to fund a defense. A parent could. I'm not saying they can't. They certainly could if they wanted to. If any wealthy couple wanted to. But again, a couple could also come to the conclusion that a child needs to.
But does
learn.
does the defendant? I'm asking this question because I'm trying to anticipate what the Attorney General is going to argue. But does the defendant have a burden of showing that he does not have access? Is it enough to simply walk into court and say, I happen to be living with my mother and father, and they don't have any obligation to support me, or does he have an obligation to come in and say, I don't have access to any of their money?
Well, again, this is part of the brief of my brief where I go into the procedure, and the way I look at it and the way I read the statute, the defendant has an initial obligation to take the pauper's oath, to sign that affidavit, and to also sign any releases to the government that can give them access to his tax returns in the Commonwealth or bank account information. And then the burden shifts to the government to prove that he is not indigent, that he doesn't require. And that would be the probation officer's or the probation department's obligation.
If a person in this position, in these circumstances, is paying room and board to his parents, does that make the inquiry easier?
Well, if they're paying room and board, that shows that they have access to some income.
Well, $50 a month, room and board.
That shows that they have access to $50, at least with respect to housing. And you take into account the cost of housing the cost of living when you're doing the determination of indigency.
Well, wait a minute. Help me out for a minute here.
Sure.
He's making $200. He's making the defendant's making $100 a month. It's some kind of a job.
Okay.
He's paying $50 a month room and board to his parents. So he's making $1,200 a year. I take it that's well within the indigency standard.
Yes, that would be yes.
And he's paying half of his income to his parents as room and board. Does the fact that he's paying room and board to his parents end the inquiry?
I'm not sure what you're asking.
Does that statement, I am paying $50 a month room and board to my parents, does it establish that he has no access to their money?
I don't think that establishes it one way or the other. I mean, I think what you look at when you're looking at whether a person has access to funds, are they a signer on an account of which their parents...
How about largesse? I have access to their largesse. That doesn't...
But that's at the discretion of the parents. I mean, the parents could decide to send
But
him
isn't
to
it
college.
incumbent upon the defendant to come forward and say, I don't have access to their largesse? My parents are Bill and Melinda Gates, but they have said that they will not pay for this.
Again, that's what that initial affidavit is, that taking that oath saying that I'm indigent. That's what the defendant is saying. He might have the ability to go to his parents and say, I need $30,000 for college, but that doesn't impact whether he has access to their funds for an attorney.
May I follow up on that? Now, in this case, there was a $10,000 bail, right?
Yes.
Who paid the bail?
The
I can't
girlfriend
s-
didn't the
I
girlfriend?
thought the girlfriend's
Got it from
mother came up with the money for the bail.
Yes, that's true.
So that's available funds, isn't it? I mean, if you're going to bail someone out,
It depends on whether he has access to it, though, or not.
well, he got the benefit of it.
He did receive the benefit with bail, yeah. But
So there
that
were
doesn't-
resources available to bail him out.
There were resources available to bail him out. But again, what we're talking about here is whether he has access to funds that are going to allow him to hire an attorney. And again, just because you have access to funds for bail or for any other,
Yes, but the fact is that the person who's, I think the record would say, if it is the girlfriend who came up with the money, that's the person with whom he lives.
that's true. But again, it was never shown that he had access to her funds. And in this case,
Does that
she's the
get to the-
defendant.
Does that get to the burden question? Is that, you say that the Commonwealth had to show that, or would it, is it, everybody else seems to argue that the defendant is the one that has the burden here?
Well, yes, that's case law, and in the Commonwealth, that's a good one. And we argue in the brief that that's incorrect, because if you look at the statute, it clearly says, and I'm reading from Chapter 111D, 2.5b, it shall be the responsibility of the chief probation officer assigned to each court to ensure that a person claiming to be indigent meets the definition of indigency under Section 2.
Counsel, I'm sorry, your time is up. Thank you.
Good morning. May it please the Court. Assistant Attorney General Natalie Monroe on behalf of the Administrative Office of the Trial Court. The Court should either dismiss this case as moot or rule that the trial judge's indigency determination was correct as a matter of law, and I will focus my comments on the Court's ruling. The trial court's determination was correct as a matter of law because, 1, the trial court correctly placed the burden of proof on the defendant. 2, the household provisions in Rule 310 are constitutional. And 3, the trial court correctly applied the household provisions to Mr. Fico.
Yeah, if I can move to that issue. Let's assume that she is correct and that there was sufficient income if one includes a parent with whom he lived, and you incorporate then her income, and let's assume that that means that he would not be indigent. And then let's assume that a few weeks later he comes back and says she won't pay. What happens?
The court absolutely should re-examine the defendant's indigency status, and I would say it's not enough for a defendant to simply come forward and say, my mother is not willing to pay. I think the defendant needs to provide a sufficient information to the court to satisfy the court that, in fact, even though the defendant is living with Bill and Melinda Gates, they are completely unwilling to pay.
Okay, so let's assume he then calls Mr. and Mrs. Gates to the stand, and they say, we're tired of supporting him. He has to be on his own, and we're not going to pay a penny.
If the court finds that testimony credible under Section 4B of Rule 310, the court has the discretion to set aside the indigency definitions and find that the defendant is indigent.
Okay, and if the court does not find that credible, and then the defendant then proceeds to trial without counsel, has he waived his right to counsel in that circumstance?
The court should be very reluctant to proceed to trial, and I would stress that under Section 7 of the rule, the defendant's indigency status may be reviewed at any time. So before proceeding to trial or before finding that the defendant has in fact waived his right to waived his right to counsel, the court should examine the facts very, very carefully, and it may be appropriate in those circumstances to do a reexamination and appoint counsel.
Okay, because you agree that there can be waiver by conduct of the right to counsel only if the individual truly has enough money or has access to enough money to afford counsel.
That is correct. But the rule, I think, is properly structured to give the court, it's probably structured in two ways. It puts the burden on the defendant to demonstrate that he is indigent, and it gives the court a wide amount of discretion in order to make the determination.
Could I just follow up on that question? Yes. The rule, as you interpret it, seems to make an assumption that if an adult is living with parents and not paying any money, that not only can you assume that they are supplying a benefit to the amount of a room and board, which perhaps one could do. I can think of a number of other federal and other benefit statutes that impute that kind of availability. But you're saying that once you impute that they're there, then that little amount is actually opened up, and an assumption exists that everything that parent has is available to pay for fees, for attorney's fees. That's an extraordinary assumption when there is, in the absence of a legal obligation, but that's what I understand the position to be.
With respect, I read the household provisions a little differently than that. The household provisions provide for a parent or a spouse to the court only looks at the parent or the spouse's income and assets if that person is already substantially supporting the defendant or the defendant's household.
So they're in there and they are not paying room and board, so that's substantial support? right?
That is
Right.
correct. So
So in those circumstances, you're saying that except for someone who, let's say a spouse might have an obligation because of the necessaries concept, but we're talking about an able-bodied adult who doesn't have a job, who lives with a parent who has no legal obligation. Because the parent says, yes, you can stay here, and don't worry, until you get a job you don't have to pay, in those circumstances, your reading is that that parent's income and assets then become available to pay for attorney's fees.
that is exactly what Section 1B3 of Rule 310 provides. That's exactly what it states.
So the best thing that a parent can do is kick out the kid and say, go sleep on the fire escape right behind the courthouse.
Well, I take
That
it
is-
as you suggested,
well,
there's a two-step process.
yeah.
One is that that income or those assets can be considered initially on the question of indigency, but I think as you answered Justice Gantz, if the defendant can demonstrate that they actually are not available to him, then that sort of presumption goes away.
That's exactly right, and all that does is allow the court to look at the financial reality of the situation. In this, I'm sorry, go on.
Well, I just want to get into that zone. Okay. Defendant has come forward, has affidavits from his parents or something saying, no, we're not doing this. And I think you said, now that sort of gets you into the zone of the judge's discretion, right?
Correct.
But wouldn't it, assuming that either they testified or let's just say there's affidavits, could the judge nonetheless, in the proper exercise of discretion, say, I have these affidavits and I have no counter evidence, but I don't choose to go that way. I'm going to exercise my discretion and say, you, Mr. Defendant, are not indigent. Wouldn't that be an abuse of discretion at that point?
The judge could not do that. The judge could find that she did not find the witnesses credible. That's certainly within her purview, but she certainly couldn't say,
Okay, once she
I
finds
find
them
it's
credible, the discretion's
She
over.
does not have that discretion. That is correct.
Here, it appears as if the judge factored in that someone came forward to bail him out. Is that a consideration that a judge would make in making an assessment about whether there are available funds available?
Yes, it certainly shouldn't be the only factor, but yes, it is a consideration because, for example, in this instance, the defendant's girlfriend came up with $10,000 in cash within 3 business days of him being placed on bail. And that goes to 2 factors. That goes to whether they are in substantially the same relationship as a husband and wife and whether she has available funds, what her available funds are. And I think it's important to point out in this case 2 things. I do believe that the court did look at Mrs. Barbario's available funds. The court asked questions about Mrs. Barbario and whether she owned her own home, for example, and on page 25 of the record appendix in the judge's ruling, she specifically referred to the mother. Secondly,
And I'm sorry, is that error?
pardon?
Is that error? The rule does not speak of your in-laws or your in-law equivalent. It speaks of your parents.
Actually, Section 1B2 of the statute provides that the court can consider both the assets of a spouse and the spouse, or someone living in the same, substantially the same relationship as a spouse, and the spouse's parents, provided that the defendant is living with the spouse's parent and the spouse's parent is contributing substantially towards the household's living expenses. So it actually, the judge could have considered properly
This is in 1B2?
that is correct.
I don't. Show me the language that speaks of the spouse's parents, that the in-laws are obligated to pay. That puts a bit of a burden on the in-law relationship.
If you look at the first full sentence, a party's available funds shall include the liquid assets and disposable net monthly income of the party's spouse, and then the parentheses, and each of the party's parents.
Right, and the
So
party
each-
is the defendant.
In this instance, it says each of the party's parents. I take that to read, to mean the spouse and the defendant.
Spouse is a party?
Well,
It says each, but that's
It's
usually
not-
a mother and a father. There usually often are two.
it doesn't say each parent of the party, it's each of the party's parents. That is how I read it. Perhaps I'm reading it incorrectly, but I believe that is how it is written. And I see my time is up, so unless the court has further questions, I'll rest on my brief.
Thank you.
Thank you.